2023, which was passed last month on August 11. This act was notified after much deliberation, after several bills which were introduced in the parliament, and finally came to the picture on August 11, 2023. And although this act has been notified in the Gazette, but it is yet to be applicable. So right now, the idea behind this webinar is to introduce you with this act, as to what is the act talking about, what are the risks, what are the compliances that you're required to do, and how this is going to change the personal data protection and related issues in the country. Harsh, I think we can move to the next slide, please. So introducing you with how this Digital Personal Data Protection Act 2023 came into being. So as I just told you, that this act finally received the assent of the president and was notified in the Gazette on 11th August 2023. However, it is yet to be notified by the central government. But this all started from back in 2017, when Justice B.N. Sai Krishna Committee was constituted to look into how we are going to work with digital data protection and how it needs to work out, considering that the entire world was talking about GDPR and data protection. There was a need for India also to have its own data protection laws, which is why this committee was constituted back in 2017. After that, a month later, this happened in July 2017, a month later, the Supreme Court was hearing a matter called Justice K.N. Puttaswamy versus Union of India, which is also known as the Aadhaar judgment. This is when the Supreme Court of India first spoke about and talked about the need of having data protection laws in the country, and that there should be a Personal Data Protection Act or a law which needs to be constituted. And they set down some guidelines. On the basis of those guidelines, in the year 2019, a personal data protection bill was introduced in the Lok Sabha. After much deliberations and discussions, and there was some delay due to COVID, this particular bill was withdrawn in 2022, and a new bill was introduced in its place. Instead of it being a personal data protection bill, the revised bill was called the Digital Personal Data Protection Bill. Finally, in 2023, the cabinet gave its permission, the bill passed in the parliament, and finally received the assent of the president in August 2023, and came to be known as the Digital Personal Data Protection Act 2023, as we know it today. Moving on. So what is this Digital Personal Data Protection Act? What does it really talk about? What does it cover? So I'm just giving you highlights for now as to what this act covers. This Digital Personal Data Protection Act talks about how we are supposed to maintain, how we are supposed to deal with data protection issues in the country. The idea is to encourage organizations to protect the data data that you're collecting while safeguarding the freedom of the individuals. So, to safeguard this new act came into being. And the highlights of this act are basically to cover digitized personal data. So this act is only applicable on data which is gathered digitally, or any data which is gathered offline and later on converted into a digital format. So in case you're gathering any data in an offline format, not digitizing then that particular data, then this particular act is not applicable. This is only applicable on digital form of data, whether it's collected online or collected offline and then converted into a digital format. Also, this particular act, so when the bills were being introduced in the parliament, I don't know if you've attended the last webinar, we spoke about something called a deemed consent. So there was a lot of talk in the previous bills about deemed consent, but by the time this act came into the picture, the bill finally received the assent, went through multiple amendments before it being passed into an act. The term deemed consent was modified, and now it is said that deemed consent can only be used for certain legitimate uses. Otherwise, when you're collecting data, digital personal data, there has to be specific and clear consent. So, which means that basically only when there are legitimate reasons, for example, somebody has applied online for getting a benefit under a government scheme, then it is then the consent given for application for that particular government scheme is considered, that is a specific consent, right? So it is considered that you have also given your deemed consent for your application to be considered for similarly placed eligible schemes where you might be eligible, right? So these can be one of the legitimate reasons. So for certain legitimate reasons, or for reasons of national security, or on orders of the court or the government, you are sharing the data with some different agency, which could be a government agency or a court, and your consent is considered to be a deemed consent at that point in time. And that's why a specific consent is not required, only for those specific legitimate purposes. Also, under this act, cross-border transfers of data are allowed and are valid. There are certain restrictions to it. So, I mean, the restrictions are only with respect to where central government notifies that you can't transfer the data to a third country. Otherwise, your cross-border data transfer is allowed under this act. Also, the valid contract is mandatory for data processor. So basically what it says that when you sorry, so basically what it says that as a data processor, when you are getting the consent, so when you are getting any data, when you're collecting any data, you have to get a valid consent. It is a mandatory document that you have to get a written consent. It could be by a click of a button or by filling up a form from the data principal, from the person who's giving their data. So as a data processor, when you're processing it, you need to have a valid consent. Like I mentioned, you need to have a specific consent unless there is a deemed consent for legitimate purposes. This is what it talks about. Okay. Then next is that expiry of retention period if the data is unused. So this act also talks about that if you've collected the data for a specific purpose, and that purpose has been fulfilled, or you are not using that data anymore, you're not using it for that purpose, then the data expires. Basically, you can't retain that data anymore. You have to delete that data the minute that purpose of the collection of the data is fulfilled. All right. Also, for now, there is an exemption for 5 years for data fiduciary by the central government as in when they notify it with respect to application of certain provisions. So we understand in the new Data Protection Act, there are a number of compliances that the data fiduciary has to take care of. There are a number of penalties that would be applicable on data fiduciary if those compliances are not fulfilled, which is why for now, the central government has the power to exempt the data fiduciaries from doing those compliances, fulfilling those compliances for a period of 5 years. However, this exemption will be specifically granted once the act is notified, and once the central government tells you that these particular sections or these particular compliances will not be applicable. I mean, it's not given in the act. The central government will notify it in the later date, but central government does have the power to exempt the data fiduciaries for a period of 5 years from the enactment of the act. All right, moving on. Right. So, right. Another one of the major highlights of this new Data Protection Act is that one who collects the data of children cannot use the data for tracking or behaviorally monitoring or targeting ads to children. So the intention behind this is to protect the interests of minors, which is why this protection is given under the act, that in case a minor has provided their personal data or you're tracking a minor's data, you cannot use that personal data. Okay. Now, another defined term which in the act is a significant data fiduciary. So for a significant data fiduciary, the compliances given for general data fiduciaries are same. However, there is an added compliance for significant data fiduciary, which is to appoint a data protection officer. The data protection officer is supposed to ensure that the data is protected, there's no being any harm, and in case there is a grievance redressal, the data protection officer is going to take care of that. Also, another highlight of this act is that all the consent managers, people who are tracking, who are collecting the consent of the data principal, the person who's giving the consent. So those consent managers are required to be registered with the Data Protection Board. So there will be a new body created under this act, a Data Protection Board. So all data fiduciaries will have to register their consent managers with the Data Protection Board. All right. Now, privacy notice. So this is a very interesting highlight of the Data Protection Act, that under this act, when you give the privacy notice, so whenever you're gathering the data, whenever you're collecting a data, you have to give a notice saying that, we are collecting this data, it will be used for, quality and processing purposes, etc. That data can be provided in English and any other 22 languages of the country which are notified in the 8th schedule of the Constitution of India. So this basically gives the, it makes it easy for people who do not have a great command of English or would prefer their local language, that they will be able to read this privacy notice online in their local language before it is, before their consent is collected for data processing, right? Now moving on, another highlight is the data principal's right to nominate. So basically what it says, that as a data principal, that is me who's giving the data, I have the right to nominate somebody else, that in case I am not fit to give my own consent, then I can nominate another person who will handle my data in case I'm not available. For example, somebody becomes incapacitated or there is a death of that person. Then after the death of that person, what happens to the data which is collected, right? So then as a data principal, I would have nominated somebody else. Let's say I've nominated, my friend who will be, my nominee for handling it. Then my friend as my nominee can take care of the data, my data which was collected. And since I'm dead or incapacitated, he or she can take the decisions with respect to that data, whether we want to withdraw the consent, we want that there is some issue with respect to that data, correction or deletion or any grievance redressal whatsoever. Okay. Now the final highlight of the bill is that there are no criminal penalties under this act. So in case there is a default, there is no criminal penalty, no imprisonment whatsoever. Earlier under the bill, the penalties, financial penalties went up to 500 crores. But by the time this bill got its assent and became the act, those penalties also were reduced. So the maximum financial penalty under this act is up to 250 crore rupees. Moving on. Right. So what is the purpose of the Digital Personal Data Protection Act? So the purpose of this act is to provide for processing of digital personal data in a manner that recognizes both the rights of the individuals to protect their personal data and the need to process personal data for lawful purposes and matters connected therewith or incidental to. Like I said, the idea behind this Data Protection Act is to ensure that personal data which is collected is secured in a manner so as to protect the interests of the individuals, and how that data will be processed and retained by the people who are collecting and retaining that data and using it for whatever purpose they're collecting it for. All right, moving on. Okay, so key stakeholders. I've been talking about data principal, data fiduciary, significant data fiduciary. Who are these people? What are these terms? These are the key stakeholders which are defined under the Act. Section 2 of the Data Protection Act has defined these terms. And basically, I'll give you an introduction to who these people are. One of the key stakeholder is the data principal. Data principal is an individual who within the territory of India has given their personal data which is being processed. So it could be anybody like you and me who's given our data or consent that you can use my data for whatever purpose that you are doing. Let's say I open a bank account and I open a digital bank account online, right? So I'm giving my data. When I'm giving my data, I'm giving my Aadhaar details, my name, address, phone number. So I am the data principal in that case. All right. Now, who's a data fiduciary? Data fiduciary are the organizations, not individuals. These are organizations who are collecting the data and deciding that what purpose this collected data will be used for. So in the example that I just gave you, that I'm trying to open a bank account, a digital bank account, and I filled an online form. So that particular bank who's collecting my data and retaining it for the purposes of opening my bank account is the data fiduciary, right? But then who's a significant data fiduciary, and what's the difference between data fiduciary and a significant data fiduciary? Data fiduciary is an organization, can be a small organization, a mid-level organization, MSME, could be anybody, any company, any entity, any organization that is collecting data. But a significant data fiduciary is a big organization which is collecting large volumes of sensitive data, right? So it could be somebody as big as, let's say, somebody like Facebook, who's collecting a lot of data, or somebody like Google, who's tracking every single move, who's tracking our Google searches, what we are finding. Facebook is tracking how we are reacting to a personal, to a particular advertisement, or how we are commenting and what are our activities online. Or somebody like a WhatsApp, who's tracking that at what time, who are we texting, what are we texting. So any entity which is collecting large volumes of sensitive data, they are significant data fiduciaries. However, as per Section 2 of the Act, it says that with respect to significant data fiduciaries, the size to how large a volume will determine that whether you're a significant data fiduciary or not. It will be determined by the Government of India as per the terms given in Section 10. And when you read the Section 10, you come to realize that the Government of India, the central government, has to notify that volume. So once the Government of India notifies a volume that somebody who's dealing with, let's say 10 million data collected, 10 million data principles data collected in a day, in a period of 24 hours. This is an example I'm giving you, okay? So that particular entity would be termed as significant data fiduciary. So right now we are waiting on that number, what that number is going to be. Like I said, that the act has come into place, but it is not yet come into effect, because the Government of India has to decide on when it is going to be applicable, how it's going to be applicable, and which all sections are going to be applicable. So when that happens, the central government will also give us the number or the volume which determines that when a data fiduciary becomes a significant data fiduciary. All right. Then the next key stakeholder is a data processor. Data processor is different from your data fiduciary. Unlike your data fiduciary, data processors are organizations that are processing the data on behalf of data fiduciaries. For example, when we apply for a passports, we go to the Ministry of External Affairs, right? We go to the passport office. We give them our information, and they work like data fiduciaries. They collect our data from us. However, that data is not processed by themselves. So they have outsourced it to companies like TCS and the other private organizations who are there collecting, who are processing that data, filtering out and retaining that record for the Government of India. So those organizations are data processors, not the people who collect the data themselves. All right. And then the last key stakeholder is a consent manager. Like I mentioned earlier, that significant data fiduciaries are required to have consent managers, and consent managers are required to be registered with the Data Protection Board. Consent managers are those people who assist data principals and data fiduciaries to manage, review, and withdraw consent. So basically, under this act, like I mentioned earlier, that as a data principal or somebody who's providing the data, I have the right to withdraw my consent anytime. So today I'm giving my consent that you can use my data. Tomorrow, I may realize that, my data is being misused, or I don't want you to use my data anymore. So I can contact the consent manager of that particular data fiduciary and withdraw my consent. Or let's say, my data which is collected is incorrect. when I've opened a bank account, they have my incorrect email ID or incorrect phone number. And the data I've given to them there was some mistake with respect to that, which is when I approach the consent manager as the data principal, who's going to assist me to review and fix and manage that issue, that consent. All right. So these are the 5 important stakeholders under the new Data Protection Act. Moving on. Okay. So now I'll give you the overview of the DPDP Act, the Digital Personal Data Protection Act. So with respect to applicability and scope, first is your territorial scope. So basically what it says that this act would only be applicable when the data is collected in India, okay? Collected in India for the purposes of India, for purpose of Indian activity and Indian work. That is the territorial scope. The extraterritorial scope is that where this would also cover where the data is collected for outside foreign individuals, or the data is collected outside the country, outside India, but for the purposes of providing services or goods or processing in India. But basically to provide services in India. Let's say somebody wants to, I'll go back to the bank example. Somebody wants to open a bank account with an Indian bank, which has a branch in, let's say, US. Okay. So a foreign individual goes to the State Bank of India branch in New York, gives their data, and that data, because the State Bank of India is an Indian bank, which is headquartered in India. So of course the data is going to come back to India. Because they're seeking those services with the Indian bank in India, and that data is moving to India, then even though that person is a foreign citizen, foreign individual who has no role whatsoever in India, but because they're seeking services of an Indian bank, which is headquartered in India, and the processing and everything is being done through India, then under the extraterritorial scope, this particular act would also be applicable on the data collected for that particular individual. All right. Now coming to exempted personal data. Now there are certain kinds of personal data which is exempt from the application under this act. Those kind of data are basically where you have where that personal information is made publicly available either by choice or by legal obligation, which in simple language means that where you've given that particular information as a public information, like let's say you've posted something on your Facebook wall, you've made it as you've posted something, your personal information on Facebook, so that becomes public knowledge and hence not covered under this act. Or let's say there is a direction of the court that you have to reveal this particular personal information in court, or there is an order by the government of India, or it affects the national security and safety of the country, then on these particular grounds, certain personal data will be exempt from application of the DPDP Act. Okay. Now moving to sensitive personal data. Now, earlier under the IT rules, we are aware that there were particular rules that spoke about sensitive personal data. However, under this act, there is no particular categorization of difference between personal data or sensitive personal data. On one hand, it is a very good thing. That means that your personal and your basically your sensitive and non-sensitive data is being secured and taken care of at the same level. On the other hand, that is a concern that sometimes your sensitive personal data attributes some extra authentications or extra layers of protection, let's say, your biometric details. However, this act is silent on the term sensitive personal data. This just covers personal data, whether sensitive or non-sensitive. It covers all of them. All right. Then moving on, exemptions. There are some exemptions under this act, certain obligations that are exempted, like, when there is a cross-border data transfer. Like I said, cross-border data transfer is permitted. However, there may be some restrictions from the government of India. Again, there are some exemptions which the government of India may notify on a later date, where certain obligations of data fiduciary and data principles may be exempted. So these are few things which are exempt under this act. All right. Then coming to the grounds of processing. Now, for processing of data under this act, there are two core grounds that need to be looked into. One is consent. As I mentioned earlier, that your consent should not be a deemed consent. Your consent has to be an unconditional, clear consent, which is given out of free will when you decide to provide your consent for sharing your data so that your data can be shared, processed, stored, and used by the data fiduciary and the data processors. All right. So for there should be a clear consent by the data principal under this act. Now, two, that the data that is being collected is used for legitimate purposes. Okay, so you have to define what that purpose is, why are you collecting that data, and that the data, the personal data which is being collected under this act is for legitimate uses. And as I mentioned earlier, that once the purpose of the data is used, it's over, then the retention, the right to retain also lapses. That means it expires. That if a data is collected for XYZ purpose and it is not used for that purpose, then you don't have to retain that. Then as a data collector or data fiduciary or a data processor, you can't keep the data anymore and you have to delete that data. All right. Moving on, privacy notice. So this is a wonderful thing which I earlier spoke about, that under this act, when you are giving your consent, then as a data fiduciary, when you're collecting consent, you have to post this on your portal everywhere. You have to give a privacy notice that your data is being collected for XYZ reason, and this is the privacy, and these are the rights and limited protection that you're getting under this act. And that has to be done. That notice can be made available either in English or in any of the 22 regional languages which are specified in the 8th schedule of the Constitution. All right. Moving on. Right. Data principal and data fiduciary. Data principal and data fiduciary, these terms I have already defined. I've already explained to you who data principals and data fiduciary are, but I'll do that once again. Data principal is an individual whose data is being collected, who's giving his or her consent that their data can be used. All right. In case of children, right, in case of minors, the parents or the lawful guardians are to be considered as their data principals, okay, because children cannot give consent. Now, with respect to data fiduciary are entities or organizations, individual company, firm, state, etc., who are collecting the data for the purpose and means of processing an individual's personal data. All right, moving on. Right, the obligations of the data fiduciary. Now, as a data fiduciary, there are about 8 obligations under this act that you are, as a data fiduciary, required to do. So if you're an organization who collects the data for processing, collects personal data of individuals, then these are certain obligations that you're required to do. One, that you have to implement technical and organization measures to ensure safeguard of personal data, that you have to maintain the data in a protected manner. There cannot be any breach, there cannot be a leak. So you need to have proper technical and organizational measures in place. Two, that you have to determine the legal ground of processing and obtaining the consent from data principals where required, which is why you need to have a proper consent form where you seek proper valid consent and not a deemed consent, right? Then 3, provide privacy notice when you are obtaining consent from data principals, and that privacy notice can be in English or any other 22 regional languages which are notified in the 8th schedule of the Constitution. 4, that you have to implement a mechanism for data principals to exercise their right. Now, what kind of mechanism there has to be in place? That you need to have, basically this mechanism also includes consent managers, that you have appropriate consent managers and appropriate procedure in place, that in case the data principal tomorrow wants to withdraw his or her consent with respect to the data that they have provided to you, or they want to make any changes, or they want to report anything, or there is some grievance, or they want to fix a mistake, then there has to be a proper mechanism provided so that the data principals can exercise their rights. All right, moving on. All right, the fifth obligation of the data fiduciary is to implement a grievance redressal mechanism for handling queries from data principals, because it becomes very cumbersome for individuals to approach somebody when there is a mistake or there is a grievance. There has to be a separate grievance redressal mechanism, and it is the responsibility of the data fiduciary to ensure that these grievance redressal mechanisms are in place and easily accessible by the data principals. Now, the obligation number 6 is irrecoverably delete personal data after the purpose for which it was collected has expired or when the consent has been withdrawn. So basically, this says that in case somebody withdraws their consent with respect to the personal data that they have provided to you, or that the purpose for which you've collected the data, that purpose has been fulfilled and it's over, or you've not used it and that's why the data has expired, basically you can't retain that data anymore, then you have to delete it in a manner that it is irrecoverable. So you need to have proper systems, which is why we said that you need to have proper system technical advancement and mechanisms in place, because that data needs to be deleted in a manner that it is absolutely irrecoverable and there cannot be any malified incidences in the future. All right. Now, the seventh obligation is that as a data fiduciary, you're required to have a breach management policy to notify the data protection and the data principals in accordance with the prescribed timelines. So these timelines are yet to be defined by the central government, but what this data breach management policy basically is that you're required to have a policy in place in case there is a breach tomorrow, that you've collected as a data fiduciary, you've collected information, you've retained it, and there is a breach. Let's say, there is a hack or a Trojan or a virus, and that data has leaked. Then as a data fiduciary, it's your responsibility to notify the data protection board and the data principals that there has been a breach of this data, your data has been breached. And when there is a breach, for that purpose, you need to have a proper mechanism or a policy in place, that what are the steps you're going to do, how you're going to process it, how you're going to safeguard the interests of the data principals when there has been such there's been such a breach. All right. Now, obligation number 8 is sign a valid contract with data processors to ensure key obligations are abided by them, including timely deletion of data. So we understand that as a data fiduciary, you are just collecting data. You're not processing it yourself. You are outsourcing it to a data processor or a third party who's processing the data, which is why all data fiduciaries are required to have a proper valid contract with all data processors to ensure that all the terms and the conditions and the compliances under the Act are taken care of and protected by the data processors, and also to ensure that the data processor also deletes the data timely, as in when, as per the law, right? So that, because if the data processor also fails to do that, that obligation vicariously will also fall upon the data fiduciary, which is why you need to have a valid document or a valid contract with the data processors as well. Moving on. Right. Obligations of the significant data fiduciary. So significant data fiduciaries are going to have absolutely identical obligations. I mean, in addition to the general obligations that they have that are applicable on data fiduciaries, there are 3 additional responsibilities or obligations on the significant data fiduciary on what they're required to do. So obligation number 1, the additional obligation number 1 is that a significant data fiduciary is required to appoint a data protection officer in India. And that data protection officer will ensure that proper compliances are taken care of, the data is protected, and time to time approach and intimate the data protection board. 2, that the significant data protection has to appoint an independent data auditor to carry out periodic data audits, right? So you have to appoint an independent auditor who's going to do data audits and ensure everything is in compliance, right? And 3, that you have to, as a significant data fiduciary, you have to conduct data protection impact assessment periodically. All right. So these are the 3 additional obligations on only the significant data fiduciaries. Now moving on. Okay. Rights of data principal. Now, as I mentioned earlier, that data principal is the person who's giving their right or giving their consent that their data can be used. There are certain rights under this act which are available to the data principal. One, of course, is the right to grievance redressal, that they can approach the data fiduciary and ensure that whatever the grievance is being resolved. There is a timeline given to it under the act. That the data principal has to that the grievance redressal has to respond to the data principal within 7 days or shorter, or as a period that may be prescribed. Of course, most of these sections are yet to be applicable. None of them are applicable as of today, but let's see as to how the government is going to amend these timelines, how they're going to allow that these particular provisions come into place, whether the entire act is going to come into place together or it's going to be in bits and pieces. Some sections may be notified later on and maybe not today. All right. So another right of the data principal is right to data portability. So yes, you can always ask as a data principal, you can always ask that your data be extracted and transferred, right? Then next is transfer to another entity. So you can always ask that you have my XYZ document, can you share it with the third party? You can always give that, you have that right for data portability, and you can give that consent as a data principal. Then your next right as a data principal is your right to access. So tomorrow, let's say you want to access the information that you have provided. So personal data you've provided today, 5 years down the line, you say that, I want to access the information that I gave you 5 years ago. So as a data principal, it is your right to gather that information, to access that information, that consent that you had provided earlier under this act, right? And fourth is the right to nominate, which means that in case you are incapacitated, dead, or unavailable, basically in case of incapacity and death, you have the right to nominate another person, another individual who will be your nominee and take care of your data protection rights. All right, moving on. Right, we spoke about the data protection board. So what is this data protection board? Like I mentioned, under this act, a separate regulatory body is being framed, which is called the data protection board. Right now, considering the timeline we are going in, the act was enacted in 2023. It is likely to come into place in 2024. So it seems like that the government is going to give another 1 year for that, for all the entities and all individuals and organizations to smoothly streamline themselves as per the law. And probably by 2025, they would establish a data protection board. So this data protection board will be established by the central government and it would be notified, right? It would constitute of technical experts who have the understanding of the industry and how it works. This data protection board would deal with grievances and complaint redressal. So any individuals or companies or anybody who has a complaint, whether against a data fiduciary or significant data fiduciary or a data processor or vice versa, then all the complaints, so all adjudication would take place by the data protection board. And of course, the key functions of the board would be to monitor the compliance and impose penalties, to direct data fiduciaries to take necessary measures and steps, and of course, hear grievances whenever made by affected persons, right? So this is the purpose of the data protection board. Moving on. Cross-border data transfers. Like I mentioned, that cross-border data transfers are now permitted under this new Data Protection Act. However, there is one limitation, that in case the central government notifies and mentions that data cannot be transferred to XYZ countries. Let's say they list out 3 countries where it says that you can't freely transfer data, then only for those countries data transfer cannot take place. However, cross-border data transfer is allowed under this act without any restrictions from the government. All right. Moving on. Penalties and exemptions, right? So this, like I mentioned earlier, there are no imprisonment, no criminal penalties under this act, no imprisonment whatsoever. However, there are financial penalties. Financial penalties can go up to 250 crore rupees on organizations. However, on individuals, that penalty can go up to 10,000 rupees. Okay, in case it's on an individual and a consent manager on, so then the limit of the penalty is up to 10,000 rupees. There are certain exemptions also on these penalties, on basically exemptions on the compliances as to when penalties would not be applicable. So these exemptions would depend upon what the government notifies, and of course with respect to national security related versions. And whenever there is an exemption granted by, let's say, the court, the government, or on account of any particular law in the country, then of course certain activities are exempted from being penalized, and that's where certain compliances won't take place. I'm sorry, moving on. Right, now road to compliances. What are you as as organization required to do in order to comply with the new Data Protection Act? So if you're a significant data fiduciary, then of course you have to appoint a data protection officer and publish his or her business contact information. As a data fiduciary, you have to draft a privacy notice to inform the data principal when you're collecting their data. Then then also as a data fiduciary, you have to inform data principals about the information, the personal data that you're collecting from them, and the purpose of that information. You have to have privacy policies and procedures of your organization in place. You have to have proper templates ready with respect to data principals rights requests in case they want to approach. You have to have a proper grievance redressal policy or grievance redressal mechanism in place so that the data principals on a later date can utilize those facilities. You need to implement technical and organizational measures to ensure that there's reasonable security safeguards. You also have to involve the data processor by signing a valid contract with them so that the liability and the risks can be reduced. Of course, you also have to maintain personal data breach notification template for the board and the data principal, because the minute there is a breach, you have to immediately intimate both the data protection board and the data principal. Also, you need to, as a significant data fiduciary, you would also need to undertake data protection impact assessment from time to time and appoint an independent data auditor from time to time. And of course, ensure that all the objects of this act are met. So as an organization, these are few compliances that you may have to do in the coming future once this act comes into place, once this gets notified and it becomes a law which is applicable. As of today, the law is not applicable. The date is yet to be notified, although it's printed in the Gazette. Moving on. So what are the positive aspects of this new DPDP Act? Of course, it boosts growth and innovation. It empowers the data principal. It protects their rights. It provides alternative to consent-based processing, that you have to have a valid consent in order to deem consent. It distributes the liability between organizations, that entire liability does not fall upon the data fiduciary or the data collector, but it is divided between the data fiduciary, the data processor, the consent manager, and the significant data fiduciary, and so on and so forth. Then, of course, under this act, there is a proper, effective data processing, grievance redressal system in place. There is an increased accountability on all the organizations and the individuals by way of heavy penalties. The implementation, there is an ease in implementation, and of course, there's going to be a smooth, slow rollout of the act. So it's slowly and steadily going to come into place, and the government will give all the organizations sufficient time to adopt these, adopt this act and adopt the policies under it. And of course, there are relaxations with respect to cross-border transfer. There are no permits or no sanctions that you have to get beforehand before sharing cross-border data transfer, unless there is a restriction from the government of India with respect to certain destinations or certain countries. So these are the positive aspects of the DPDP Act. And we finally come to the end of our webinar. I hope all of you enjoyed it, and I'm happy to take any questions that you may have now.
Yes, Khyati. So we have one question with us from Simatani ji. Please briefly explain the terms also like significant data fiduciary.
Right. So as I mentioned, significant data fiduciary are those data fiduciaries, those organizations that are collecting the data in large volumes. Somebody like your Facebook, Google, or a WhatsApp. What that large volume, that number is going to be, has still not been notified by the central government. But the minute that number comes, we would have a better picture. As of now, we can only assume it's going to be somebody who's collecting large volumes of data every day from the individuals. So that is the significant data fiduciary. And like I mentioned, that as a significant data fiduciary, they have added responsibilities that they need to have data processing officer. They have to appoint, they have to have proper checks and mechanisms, they have to have an independent auditor, and they have to conduct data protection impact assessments from time to time.
Okay. Then she's asking whether foreigners in India gives data, whether falls under data principle.
Yes, any data given by any individual, whether a foreigner or an Indian, when collected for the purposes of providing services or goods, for the purposes of using it in India, then yes, that data falls under the definition. That person becomes the data principal, and then this falls under the definition of data collection, and falls under the provisions of this particular act.
Thank you, Khyati. Then we have, is consent manager an individual or an organization?
For now, our understanding is that consent managers are individuals, but let's see how the government of India notifies it, because again, the act says that this needs to be notified as to who that consent manager is going to be. But our understanding is that it's going to be an individual. You have to define one person, one officer concerned who will be a consent manager in the company. Or it could just be a team, but let's wait and watch as to what the government notifies, because these things are going to come as part of rules and regulations along with the act.
Thank you so much, Khyati. Then we have Rituja with us, who is asking when will the act come in force?
As I mentioned earlier, it seems like that the act should come into place by the end of this year or maybe 2024. We are just waiting for that notification by the central government as to when it's going to be applicable. It is already printed in the Gazette on the 11th of August. So the act has become the law of the land. But when it's going to be notified or when it's going to take into effect, that needs to be decided by the central government. So keeping our fingers crossed, should happen anytime soon. Okay. But of course, there's going to be a slow rollout. So, I mean, you don't need to fear. And of course, there are powers given under the act that there are going to be some exemptions on the compliances for a period of 5 years. Again, that will also be notified by the central government.
Then one more question from Rituja is how organization can practically implement WRT and personal data storage of notices, consents, etc.
Sorry, could you repeat the question? Your voice cracked.
How organization can practically implement WRT to personal data, storage of notices, consents, etc.
You need to have proper mechanisms in place, which is why I mentioned, if you remember the last slide, the road to compliance, I've mentioned about 6-7 things that needs to be done by an organization to ensure that you're maintaining your data, you're maintaining those notices. Of course, you need to have these drafts in place, already ready in place. And the minute the law becomes into place, you need to have this available on your portal whenever you're collecting consent. So if you're collecting this consent online, you have to give this notice immediately on the portal. In case you're collecting it offline and then digitizing, then of course you need to give this consent offline again. And then when you're seeking consent, at least it needs to be part of that particular form. Like I said, there needs to be a lot of technological implementation that you'll need to do, and of course engage a good legal team and have these documentations ready as drafts and as policies, so that your company is absolutely in compliance with the new law.
Okay. Thank you, Khyati. Then we have whether e-commerce companies or aggregator platforms will fall under significant data fiduciary.
Okay, so we are waiting on what number, what large volume number the government defines. So they may fall under significant data fiduciary. However, like I mentioned earlier, that certain data which is collected online is public information. Then in that case, those people are exempt from the application under this law. So somebody like an e-commerce website, if you're collecting, if you're collecting a personal data which is publicly available, then of course, you are exempt. But if you're collecting data which is not publicly exempt, like you're collecting the address, phone number, etc., which is not otherwise freely available, or you're collecting some additional details with respect to what are the choices of that particular individual to give them targeted ads, then of course, then this particular act would be applicable on you. And whether you would fall under, as an e-commerce entity, fall under the category of significant data fiduciary, only the time will tell once the government notifies how big, how large that volume would be. But our understanding is, considering that huge, big e-commerce entities would definitely be the significant data fiduciary. Somebody like an Amazon or Flipkart would definitely be a significant data fiduciary. At least that is what our understanding is for now.
Thank you, Khyati. Then we have a question. A company engaged in manufacturing activities who processes information about their clients who are companies and not individuals, are they also required to comply with these provisions?
Absolutely, absolutely. Any information, any personal information which is collected online or offline and then digitized, they are all applicable, except where information is collected or data is collected for domestic purposes. So let's say if I am only collecting some data of say my particular family, and I'm preparing a list of guests for some event that I want to host, then of course those then I'm not bound by this act, then it's not applicable on me, I'm exempt. But if I am retaining the data of my clients, who could be individuals or corporates, and using it for whatever XYZ purpose, for business purposes, basically, then this particular act would be applicable on us. Then we are not exempt.
Then we have a question. How does the Personal Data Protection Bill propose to regulate the process of personal data by government agencies?
Government agencies are exempt from the application of this law. So you understand this, that's the case with all laws, that government agencies have certain protections. But of course, government agencies would also have to implement a proper system in place. They would also have safe security measures in place, strong security measures in place. They would also set up consent managers. They would also have notices, etc. However, and they would also have to delete the data which is collected for for XYZ purpose, and then not retain it for more than the purpose it is required for. But of course, there will be some exemptions granted to them, because for government agencies, I mean, it's a matter of national security again. So there's so much only you can do against the government organization or the government agency.
Then we have, is setting up data processing centers also regulated as a part of this act?
No, it doesn't talk about setting up of data processing centers. However, as a data processing center, it tells you what you're required to do, what are your compliances.
Then we have, what should be included in data processing agreements to ensure compliance with data protection regulation is in India?
Okay, as data processing agreements, when you're signing these agreements with the data processor, then you have to ensure that you take care of the responsibility with respect to the data transfer. You have proper clauses with respect to safeguarding the personal data which is collected. You have provisions with respect to storing and retention of the data. You have clauses with respect to deletion of the data and the timelines as to when that data would be deleted. Of course, so these are few things that you would want to include as part of your agreement with the data processor.
Thank you, Khyati. Then we have Reema ji with us, who is asking who all should be the part of the grievance redressal committee Should data breach notification also be part of an organization's whistleblower policy, or is it expected to have a different mechanism?
See, there's nothing defined as to who, what individuals or who are the officials concerned who would be part of the grievance redressal committee. That is the right which they've left it to the organization. However, there is a possibility that by the time Act comes into place, it's notified and the rules and regulations come into place, that the government may define some of these terms. We are still waiting on those clarifications. I mean, that still has to come. Few more changes and clarifications have to come into place.
Thank you, Khyati. Then we have a user who says, is DPDP applicable to data stored by HR of employees?
Absolutely. It's applicable on HRs also, only for domestic purposes where data is retained, collected and retained for domestic purposes, only those are exempt.
Then we have Weber with us, who is asking how to implement this law from HR and recruitment point of view in any of the entity.
Oh, there are a number of things that you would have to do. You have to have, I've mentioned all of that in the presentation, if you've heard it properly. I mean, you have to have safeguards in place, you have to have grievance mechanism redressals, you have to have your proper consent forms when you're collecting the employee data and the client data. You need to have consent managers again, and you need to have privacy notices in place. So there are a number of things you have to do. I mean, everything cannot be discussed right now, which is why, it's better you engage a counsel. It could be me, it could be anybody. Speak to your legal counsels, and I'm sure they would guide you as to what policies, because you need to have a number of policies now to streamline and make sure that you're in compliance with the law. So please engage a legal counsel now, who will help you with the setup of this entire act.
Thank you, Khyati. Then Weber is also asking, is there any exemption for MSMEs?
No exemption for MSMEs, applicable on everyone except for domestic users.
Okay. Then Rajan is asking, how can we get highlight of bill?
So that is part of the slide. So I'm sure Harsh can share these PPT with all of you, and you can see the highlights of the bill, of the act. Basically, there is one entire PPT on it.
Definitely.
One entire slide on it, sorry.
Definitely. Then Rituja is asking, DPDP related to GDPR provisions?
I mean, they are to be read together with GDPR. I mean, GDPR is an international law, that is a European law. So, I mean, Indian law cannot be applicable on a foreign law, that has to be read together. And GDPR is only applicable when you're using international information and retaining it in India and, using it for purposes, for international purposes. So again, this is the national law, that is an international law. They both will be read together, considering whether GDPR is even applicable on you or not.
Then we have one question from Rituja again, is DPDP applicable to data stored by HR department of employees?
Absolutely, it's applicable.
So thank you, Khyati. Thank you so much for the wonderful session. And I'll be dropping all the recorded session, the PPTs and the participation certificates to all the attendees.
Great. Thank you so much, Harsh, and thank you everyone for being here and attending the session. And if you have any questions, I'm happy to help. You can reach out to me on my email ID or my contact number. You can access the PPT, which Harsh will share with all of you, and hope you had an insightful session. Thank you so much.
Thank you.